Welcome back. My name is Patrick Nolan. I'm an attorney licensed in the state of Missouri. This is Pat Talks Law. Today, we're driving out. I've got juvenile court docket today. So it occurs to me that it might be the appropriate time to think about a very important issue, especially involving Missouri and our current trend and move into the medical marijuana era. It has been ungodly too long since we approved Amendment 2. There is still no dispensary in the state of Missouri selling legal medical marijuana. People are buying medical marijuana from black and gray market sources. However, that's not what we're going to talk about. What we're going to talk about is the fundamental question. Are qualified patients unqualified parents? When we get right down to the meat of the matter, is your use of medical marijuana something that can cost you custody of your children, either to the state or to the other parent in a custody case? And the answer is an unqualified maybe. I know, right? That's about useless. But when we go back in Missouri, since the Patrick case, we know that the courts cannot terminate your parental rights solely on the basis of your using marijuana. There has to be more. That more could be the manner in which it is used. Smoking around the children, leaving paraphernalia or marijuana where children are getting access to it. Those create unsafe conditions and constitute the more. So, and one of the things, we sat down and as lawyers talk, and we talk to judges. And one thing that I've heard repeatedly from judges is that if you want to remove the kids because of drug use, not even just marijuana, but most drugs in general, this isn't 20 years ago where merely testing positive for marijuana use would have your kids yanked out of the house. There has to be more. There has to be a showing to the court of why that is dangerous, what the danger to the children is. Now, this is obviously, we're talking about removal by the state at the moment, and we're going to come to domestic issues here in just a little bit between parents. So the more is the important thing. If you're consuming your medical marijuana via smoking, you have to have some arrangement, some way to ensure that you are not doing that around minor child, where a minor child will have access to it. You have to protect your medical marijuana tools, i.e. paraphernalia, and product, the same way that you would protect your OxyContin or Vicodin or other strong drugs. Or perhaps maybe insulin would be a better comparison, because your insulin is a product you have to protect. You can't leave that out for the kids to use. And you got to keep your needles away. So, where do we go from there? Well, there is a loosening, and right now there is a case that has been filed. It's already survived one round of dismissal attempts by the government that is challenging the federal government's classification of marijuana as Schedule 1, pointing out there are medical uses for it, as evidenced by the fact that more than 2/3 of the states have approved medical marijuana. That case actually has a fairly good chance just on the description of it. However, I have not I've not read the details of the case, so I can't tell you whether I think it's got a good chance of winning or not. But just on the surface, it sounds like they're making a coherent argument. And we'll look into it at some point. But in juvenile courts in Missouri, you're going to have to show that the person is using marijuana and they're using it in a manner which creates a hazard to the minor child. Okay? Not merely that they're using. And this can apply to any drug. I mean, if they're using meth, but they're not using around the kids, and they don't leave the paraphernalia and the meth residue in the living room, they don't have their dealer and their friends tromping through the house while they're stoned, then the question becomes, so what? And that's a very libertarian-esque point of view, and I love it. But Children's Division, by and large, does not feel that way. And many courts do not feel that way yet. But we're getting there in some areas, and marijuana is one of those spots where we're getting to the point of saying, hey, if you're not using it around the kids, what does it really matter? It's marijuana. It's not like it's meth. So we have that going for us as a society, as a movement, if you will. But we're not at the point where you can leave your grinder, you can leave your shatter, you can leave your bong sitting on the table when Children's Division comes knocking. Here's the deal. Put your stuff away when you're not using it. Okay? I know it's a tough concept, but clean up behind yourself, you nasty bastard. That's it. Clean up behind yourself. Okay? If you want to get stoned in your living room, man, shit, I don't care. I had this conversation with a tenant of mine the other day. And I walked in to fix a faucet for him, and he's, a very nice aroma, actually. It was a real mellow weed that he had throughout the house. Anyway, and then we mentioned it, and I commented, I'm like, dude, I'm probably the most reasonable landlord when it comes to this. I don't care. But you need to understand just how pungent of an aroma you have. It's there. Anybody who comes up to the porch can smell it. And your neighbors, have been known to be a little busybody-ish. So, you might want to, air the place out a little bit more often. And then we talked about whether or not he had a medical marijuana card, and I said, look, if you're going to smoke weed in Missouri, go get yourself a patient card. Talked about the protections on that a little bit, and I really hope that he does. Now, that puts me in a little bit of a bind because, look, they kept the house very nice. I mean, it was clean, it was neat. There was no paraphernalia out in plain sight, and that's cool. But, as a landlord, we have a policy of no smoking in our residences. Period. I don't care if it's marijuana or tobacco, no smoking. Why? Because it sucks to clean up afterwards. That's it. So, my wife is like, man, he's violating the rules by smoking. I'm like, but at least it's not freaking tobacco. Anyway, so when it comes down to whether or not you are a bad parent because you smoke weed, the answer is no. That is not the reason you are a bad parent. If you're a bad parent, you're a bad parent. I mean, you got to fix that. But don't be blaming the weed for it. If you are leaving drugs around your kids, it's going to be a problem. That's what the state. Now let's talk about your significant other. You guys live together. You smoked weed together. You did some lines of coke together once. And guess what? When you split up, that's all going to come out, and it will have all been your fault. If you have a medical marijuana card, you have an argument that you can make reasonably. Now, does that mean it's going to be a winning argument? Probably not. The fact of the matter is, substance use is something that courts take into account. If you have conditions that are serious enough to be approved for the medical marijuana card, you have conditions that may be serious enough to consider whether or not your physical and or mental condition is such that you can properly provide care, necessary care for a minor child. Look, it's an attack that's made. If you're using marijuana or you're using some other drugs and the other parent knows about it, it is an attack that will be made and will have to be defended. And guess how much case law we have on that for medical marijuana patients? None. And for the people that think that was just a racist signal, it's not. I grew up in a day and age when okay meant okay, and this also could be literally mean zero. So we don't have the case law. It's still new. Okay, as far as medical marijuana patient challenging the sufficiency of evidence in a divorce proceeding, a custody portion of a divorce proceeding, or a custody or paternity case, you know, there are a lot of factors involved there. Substance use is really only one of them. And if that's the deciding factor, if that is the only thing, then, you know, that's a case that's going to get taken up. But very rarely is that the only thing. And judges are pretty smart, man. When it comes to writing their opinions, they're going to talk about all of the other factors too. Again, it's not that you're smoking marijuana, it's the manner in which you are consuming your marijuana that creates the threat. Not that you got high or that you use CBD. It's the manner. So that's where the arguments are for the non-drug using spouse in a custody case. You know, we had one where the mother tried to, you know, claim my client was smoking weed like a fiend, you know, described the house as billowing full of marijuana smoke like something out of a Cheech and Chong movie. And how she walked to the yard and found a marijuana plant growing. And then on cross-examination, you know, asked them, you immediately left the house with your children, right? No. Wait a minute. You knowingly kept your kids in that environment, and it backfired on her. Okay, we pointed out that either she's a liar or she didn't consider it to be that big of an issue. But now she's playing it up as one because didn't want my client to have custody. So that's, it was bullshit. Straight up. So then we turn around and you use the same attacks on other people. It's ridiculous. But the essence here is, if you are a parent and you are using any illegal substances, you're going through a custody proceeding, the other side is going to make that an issue in the proceeding. You need to make a decision. Do you want to use illegal drugs, or do you want to have custody of your children? Because it comes down to that. If you're using even marijuana and you don't have a patient card in Missouri, that is going to burn your ass in court. Okay? Why? Well, marijuana is not harmful. No, but it's illegal. Which means you get stopped by a cop and you've got your kid with you, there's a very real chance that your child is going to see you hauled off to jail. If you have marijuana on you, you have a little bit in your pocket, maybe you drop some on the floorboard, maybe there's a smell of marijuana about you, now the officer is using that as grounds to search your car. a search that they wouldn't be able to undertake if you had a medical marijuana card. So, there are a lot of factors, but if you're going to smoke marijuana, get a patient card. If you have children and you're going through the stress of a divorce or paternity case, make a decision on how you're going to handle that. If you're going to smoke, make sure that you have a system set up so that there's always a sober person to provide care for the child or children, and that you are not smoking in or around the children, and that all of your materials are kept in a safe spot where the children do not have access. If you are going to consume edibles, the same thing applies. Keep it protected and make sure that you always have a sober care provider when you are using your medicine. And this doesn't just apply to marijuana, man. Look, if you're going to get shitty drunk, you're going to watch a football game and start drinking. Or you're going to watch debate and drink every time one politician calls another a liar. I wouldn't recommend doing that, by the way. That's a great way to get alcohol poisoning, especially this year. But if you're going to do that, you're going to make sure that there's somebody sober to provide care for your kids. You don't just get shitty and hope it's all right. I mean, I hope that's not your thought process. If it is, you're going to be meeting somebody from the juvenile office eventually. So, be smart. Keep your paraphernalia, keep your tools locked up, keep your marijuana locked up, put it away. When you're done, clean up behind yourself and put it away. Have a plan on when and where you're taking your medicine. Okay? If there's no smoking allowed in your apartment, man, don't piss off the landlord and challenge him on that. Go for edibles. I mean, this isn't rocket science, guys. So, anyway, that's that for today. I'd really like to hear what you think. If you think that being a qualified patient means that you are not going to be a competent parent, drop that in the comments. If you think that you can be both a qualified patient and a competent parent, please, let's hear that too. I would like to hear what you have to say on this, because there is literally nothing yet. This isn't something that has made law and gone all the way up that I know of. Not as the issue. There have been cases that have gone up, but marijuana has been an issue, not the issue. So, please let us know. Hit like, subscribe, and I'll be talking again soon.